introduced to our lovely panelists, but they are so modest. Let me read some bios so you really will know who is going to give you some great information on the changes that are occurring in the Social Security Administration world. To my left is Dr. John Shear. He is a board certified internal medicine physician. He graduated from Emory University, received his medical degree from Medical College of Georgia, and completed his residency at Parkland Memorial Hospital in Dallas, Texas. After practicing medicine for over 35 years, he retired as a hospitalist at Carolinas Medical Center in Charlotte, and he volunteered at CCLA as an Obamacare navigator through the SHIP program as a Medicare trained advisor. John formerly was a board member and volunteer at CareRing, a Charlotte nonprofit that provides health care to people with limited resources. As a Medicare member himself, he now volunteers at CCLA to help Medicare recipients navigate the Medicare maze. Love that. Thank you for everything you do. We'll kick it off with the bio for Brian Hogan, who is all the way at the far left. Brian Hogan is a legal aid of North Carolina practice group manager. Congratulations, we love that for you. For the public benefits realm, he received his BA and JD from the University of North Carolina at Chapel Hill. He's certified as a specialist in the Social Security Disability Law by North Carolina Bar. Brian currently serves on the North Carolina State Bar's Board of Legal Specialization Specialty Committee for Social Security Disability Law, and is the North Carolina Advocates for Justice Disability Advocacy Section Vice. Kicking it off to our one and only Miss Cassidy. She is the interim chief operating officer, senior attorney, and also was formerly family support and health care's program director. She studied at Charlotte School of Law and received her Juris Doctorate. Typically leads the Family Health and Support Program, which includes Health Insurance Navigator Unit, North Carolina Ombudsman Unit, Public Benefits Unit, and our Veterans Unit. She is very busy. She is responsible for driving litigation and policy initiatives aimed at expanding access to healthcare and public benefits here at Charlotte Center for Legal Advocacy. We love you for everything you do here. And our one and only attorney, Nicholas Parr. He's my personal go-to. He is one of the attorneys here in our Public Benefit Unit at Charlotte Center for Legal Advocacy. Nicholas helps people who are trying to obtain or keep Social Security benefits and Medicaid. And before coming to the Advocacy Center, Nick spent 6 years with Legal Aid of Society, Northeastern New York, and 4 years in the private sector. He received his Juris Doctorate at Rutgers School of Law in Newark, New Jersey. Thank you for all of your work you do here, Nick. And now we're going to kick it off. Why are we here today? And I think the best person on the panel who can kind of kick off the overview is Brian. So are you ready?
Thanks, Mika. So, just a few weeks ago on March 7th, Social Security issued a really important press release, and they announced that they're rescinding their policy on Social Security benefit recoupment for overpayments. So just to give you some background, prior to March of 2024, prior to March of last year, Social Security had a long-standing policy in place that if a Social Security beneficiary, a Title II beneficiary, and we'll discuss what Title II benefits are, I think at some point, received an overpayment of benefits, the administration could recoup those overpayments directly from their check, and they can actually take your whole check to recoup those overpaid benefits. In March of 2024, under prior Commissioner Martin O'Malley's commissionership at the Social Security Administration, Social Security changed that policy. And they changed it from 100% recoupment of your check to overpay, to repay an overpay benefit, to only 10% of your check could be used to overpay the benefit. And this was a major change for Social Security overpayment policy at the administration. At the time, Commissioner O'Malley said that Social Security was taking this important step because they wanted to ensure their overpayment policies did not unduly harm anyone. Commissioner O'Malley said it's unconscionable that someone would find themselves facing homelessness or unable to pay bills because Social Security withheld their entire payment for recovery of an overpayment. So since last March of 2024, this new policy had been in place. And then we learned recently on March 7th that Social Security was no longer going to follow that policy starting tomorrow, starting on March 27th of 2025. For any new overpayments that are incurred starting tomorrow, Social Security is going to resume their prior policy of taking 100% of the Social Security beneficiary's check to refund that overpayment. And I think we're going to talk about steps that beneficiaries can take to address this going forward. But that's the basic background here. And I welcome anybody else to weigh in about the shift in policy, if you would like.
That was perfectly explained. One of the questions I think people do want to know is Title II. Can we talk more about who is directly affected with these overpayments and what does it mean for a beneficiary to be a claimant to recipient?
Well, simply put, Title II benefits are benefits that are based on your work history. If you've worked, you've become what's called insured under the Social Security Act. And so that means that if you become disabled or you retire, you're eligible for basically a certain amount of monthly benefits just based on how much you made while you were working.
Can I just ask a clarifying, I hope I can speak loud enough. Now, Title II beneficiaries, I'm a non-Social Security. That is someone who is receiving Social Security disability and Social Security retirement?
Yes, yes.
Okay.
Yes, Title II includes Social Security, Social Security disability and Social Security retirement.
I can just add something to that too. So just to add something to that too, Nick. Title II benefits refers to the old age survivors and disability insurance section of the Social Security Act. So primarily, most beneficiaries under Title II are going to be people that are receiving retirement insurance benefits under the Act. The next biggest group is going to be folks that are receiving Social Security disability insurance benefits under the Act, that's SSDI. But there's a lot of other folks that receive Title II benefits that may not be aware of it. So survivors of deceased wage earners, meaning folks that were insured under the Act, are Title II beneficiaries. Those could be widows or widowers. They could be the children of survivors under a certain age. In addition, disabled widows or widowers are Title II beneficiaries. And also disabled adult children who started to receive benefits before the age of 22 or were disabled before the age of 22 can also be Title II beneficiaries. So we generally think of Title II benefits under the Act as Social Security disability insurance and retirement insurance benefits, but really there's a lot of folks in our community that receive Title II benefits that may not be aware of it. But a crucial distinction, Mika, that we can talk about is between Title II benefits and Title XVI benefits, otherwise known as SSI or Supplemental Security Income Benefits. And this is a really important distinction for the conversation that we're having today. Pass it on to talk about that. That's okay.
Sure. And so, right, the difference between Title II and Title 16 benefits are quite simply that the Title 16 benefits are benefits that are available to people who simply are not able to work or who meet the equivalent definition if they're children. And so because they're disabled, because they're unable to work, they are not, they are eligible for a certain amount of benefits. Again, that's basically the, sort of the minimum amount that they need to sort of survive. And because of that, they're also reduced based on any other income that they receive or any other assistance that they receive, such as room and board, for example. I don't know if that covered the distinction between.
Yeah, I just want to add, just for a little more lay explanation, like the Title II, you pay taxes, right? Like, it's not just that you worked, you paid that tax, that thing that you see on your paycheck that says Social Security or Medicare. You have paid for those benefits. Those are not given to you. You paid for them. Title II really covers that, and you have paid into the system, and that's what determines your benefit level at whatever point you may need to, or you qualify for receiving them, whether that's based on disability, survivors, retirement. And Title 16 really protects our most vulnerable, people who were unable to work, maybe because they were disabled since birth or at a really young age. It also protects people who are over 65 who don't have a work history that was sufficient. We have a lot of spouses who may not have qualified on the record, on the husband's record, or we have self-employed people who may not have been able to pay enough into the system to be insured. So SSI really is that program to keep our most vulnerable population having some form of income if they become disabled or reach older age and haven't been insured. So I just want to, I think it's really important to know that when you receive Title II, this isn't the government giving you something. This is something that you paid for and you put into it. It's just like any other insurance, and that's the same for Medicare as well.
And I love that overview. One thing that comes to mind is Charlotte is such a melting pot. There's a lot of transplant here that come from state to state. So I'm curious what to do when I have been hit with this overpayment. I've worked state to state, but I didn't get the original notice and I didn't update my information with the Social Security Administration office.
Sure. Yeah, I mean, obviously, if obviously at that point you need to contact Social Security. You need to get a copy of the notice. You need to identify, well, first of all, whether you have an overpayment, why they think you've been overpaid, how much they think you've been overpaid by, and if and once you have that information, you can start making decisions about whether they're correct in their assumptions, whether you're whether it makes sense for you to say no, this overpayment is wrong, you paid me exactly what I was owed, whether it's worth saying, well, actually, I cannot afford to pay this back, and this wasn't my fault, so can I have the debt forgiven? Or whether it makes sense to contact Social Security and figure out a repayment plan that's not literally taking every penny that you rely on to survive.
I just have a question. What is an overpayment?
Sure. Simply put, an overpayment is what happens when Social Security pays you more than they should have. So for example, they might say, you're eligible for $1,000 a month. If there's ever a month where they say, actually, you're not eligible for that payment, and they pay you anyway, that's an overpayment. So, the most standard, I think the most common scenario where we see an overpayment is work attempts. And the first thing I'll say about a work attempt is that this is something that Social Security encourages. If you're receiving disability benefits, if you're receiving any kind of Title II benefits, Social Security wants you to try to work. They want you to try to find a job that you can do, where, maybe if things work out, you don't have to be on disability anymore. And they have a bunch of rules that are supposed to make that easier. They have, but those rules are also very complicated. So, for example, Social Security's rules state that one requirement for being found disabled is that you're not able to perform what's called substantial gainful activity. That's earning a certain amount in a month. I believe it's currently around $1,600 a month. But they have certain rules that allow you to try to work without having those benefits interrupted. For example, they say, well, you can actually work for 9 months over a 5-year period, and if you do and during those 9 months, you won't get your benefits will stay in place. However, if you work after that 9 months, your benefits should be cut off. And so you'll get people who go to Social Security, find out that they've got this 9-month grace period, and maybe they'll work 5 months, it doesn't work out, then they work another 5 months somewhere else, and now suddenly that last month was too much. I'll have people who work 9 months, it doesn't work out, and then after that there's you're allowed to have what's called an extended period of eligibility, where if you keep working, you can and it doesn't work out, you can just tell them, like, I lost my job, and they'll start your benefits back up. But once that 3-year period runs out, then a single month where you make more than substantial gainful activity will result in your benefits being cut off entirely. So I've had cases where people worked 9 months, the job didn't work out, and then 5 years go by, they try again, they manage to scrape a couple of months together, where they make $1,600 a month, and all of a sudden they're just not eligible for benefits anymore. And if Social Security doesn't catch that, then they could come back and discover years later that they've been paying you that you've been overpaid for years. And when this happens, people can get overpayments that are in the tens of thousands of dollars. And it's not because anyone did anything wrong or they tried to lie or cheat. I've even had cases where people called Social Security and let them know they were working, and Social Security just didn't put in the right information, and now people are hit with this overpayment. They have to pay back.
And I love that you brought that up, because it takes years. Sometimes these notices, these overpayment notices, are tracked back for years. I've seen 10, I've seen 5, I've seen 1990. I think the magical question is, are they allowed to take my entire check when they find fault in an overpayment? Are they allowed to do so? And what are some solutions?
So the establishment of an overpayment itself is not about who's at fault. An overpayment just means, again, that the Social Security Administration paid you allegedly too much money. And I want to take one step back, though. We were making that important distinction before between SSI and these other programs that we're calling Title II benefits. everything that we're talking about today regarding 100% recoupment or taking full withholding of your check only relates to those Title II programs, not to the SSI program. So if you're an SSI beneficiary and you have an overpayment or you have a new overpayment starting tomorrow, the most that Social Security can ever take out of your check is 10% of your check, or $10, whichever is greater. So I think that's really important so we don't scare anybody that's watching this. If you're getting SSI, the most that Social Security can take from you for an overpayment is 10%. Now for the past year, it's also been a 10% maximum for SSDI or retirement insurance benefits or other Title II benefits. But starting tomorrow, that's going to change for new overpayments for that program. They can take your whole check. So, Mika, your question was, what can you do if you get this notice of overpayment?
Exactly, yes.
Right. There are essentially three things that you can do, and they're not exclusive. You can do all of them at the same time. So the first thing you can do is contest the merits of the underlying overpayment. It's called filing a request for reconsideration. So Social Security will notify you that you have an overpayment by sending you a document, a notice saying, notice of overpayment. They'll explain the reason, or they should be explaining the reason why you have an overpayment. And they'll explain to you in that notice what steps that you can take. What are your due process rights? And so one of them is you can say, Social Security, I don't think I actually have an overpayment. And you can file a request for reconsideration directly with the field office. You can do this online at ssa.gov, or you can do it directly with Social Security in person at a field office. And you can try to explain why Social Security is wrong about the overpayment itself. You can also request a waiver of recovery of the overpayment. This is what we call a request for waiver. This is a form that Social Security has that you would fill out. And you can ask Social Security to waive recovery because first, you're not at fault for the overpayment. That's prong number one. So if you're not at fault for the overpayment, you meet prong one. And then there are two other prongs. If you meet either, then Social Security can waive the overpayment. So one of the prongs is that it would defeat the purposes of the Social Security Act to recover those benefits from you, meaning that you would not be able to afford the necessities of day-to-day life if Social Security recovered the overpayment for you. So one, if you're not at fault, and two, it would defeat the purposes of the Social Security Act to recover. Social Security can waive that overpayment. In addition, there's another prong that you can also meet called equity and good conscience. It doesn't come up very often. So usually what you're trying to show the administration, though, is that, again, you're not at fault and you can't afford to pay it back. So that's a waiver. And you can file an appeal on the merits of the overpayment and request a waiver at the same time. And that's important for you to know. Another step that you can take is you can ask for adjustment of the recovery rate. This is another form that Social Security has that you can fill out. And essentially there, you're not necessarily contesting or agreeing to the underlying overpayment reason or the amount. But what you're asking Social Security to do is if they're going to recover from you, which they're going to do at 100% starting tomorrow from new overpayments, you can ask them to take a lower amount out of your check. And you'll be asked to provide Social Security with a bunch of information about your current expenses and your income. And if you can show them essentially that you can't afford to pay back, say, more than $20 a month, otherwise you would not be able to keep a roof over your head and food on your table, then they can also adjust recovery of the overpayment as well. So those are the three steps that you can take, but again, they're not exclusive, meaning that you can do all of them at the same time. There are deadlines, though, for certain of those actions, and does somebody want to talk about those deadlines? Okay.
So the most important deadline to know is 30 days. If you want to request reconsideration or a waiver, they will, you basically have 30 days to do either of those actions if you, if you want them to suspend their recoupment attempts, if you don't want them to garnish your check. Now, their rules say that if you, go, you know, like, if you, file your request for reconsideration or your request for waiver after that 30 days, they still have an obligation to suspend recoupment. However, they will still have grabbed at least a few of your checks, and you don't want that. A request for reconsideration pretty much has to be filed within 60 days of them sending you the notice. Now they'll assume that it took about 5 days to get there, which, yeah, I see some smiles in the crowd, but that's what they'll assume. And then an overpayment, a request for a waiver or a request for basically a repayment plan can be filed in theory at any time. And again, if they receive that request for a waiver, they do have to suspend recoupment once they process it.
I have a question. So this notice that I received from Social Security, is this a one-page letter notice, or is it something, I do tax work, and so usually, depending on what type of notice, I think of an audit notice, it can be several pages, front and back. So when I receive a notice from Social Security telling me that there may be an overpayment, is there notice explaining to me what the overpayment is, when it may have occurred, and what my rights are?
Sure, absolutely. So your, it is a several-page letter. Now, the thing I will say is that the heading of the letter will usually say something like notice of overpayment, or more usually like notice of change in benefit rate, I think is the one I usually say, or.
It says important information.
Right, important information, notice of proposed decision. But again, under their rules, they do have to say that you've been overpaid. They have to say how much you've been overpaid by, and they need to give some kind of explanation for how they calculated that overpayment and what the overpayment is based on. Now, that being said, you may notice from tax work, their notices are not always the most clear and not always explained in the plainest language. Yeah, so I don't know how helpful that is, but that's what to expect.
So I received this notice. I'm pretty sure I cannot pay these tens of thousands of dollars that is in front of me, and I don't agree with the reason. Should I even be worried about this notice in front of me?
Yes, because if you don't do anything, they will take your entire check for as long as it takes to recover their overpayment.
Don't ignore anything you get from Social Security and keep really good records. I think that, I know it's easier said than done, but that is, if you take anything away from this panel, it is to not ignore anything from Social Security and keep really good records. I think we have a
We're not
question.
taking questions until the end.
Okay, we'll take questions but when you're doing this, all of these decisions that you make, whether it's reconsideration, whether it's waiver, whether it's a change in payment amount, are going to require you to take action. So to Mika's point, and also for you to provide documentation to Social Security to back up your request, right? Whether it's an appeal and saying, this isn't right, this is what I had, this is when I reported this, and it's, unfortunately, a lot of times, the clients that we see, it may have happened 5-10 years ago, and you don't have a lot of documentation, but I always try to, I think, whatever you can sort of compile, keeping track of these things is really important to overcoming some of these overpayments. And of course, you can't just change your payment rate, but even that requires you to kind of show why and keep track of your monthly expenses. So it's not something that will just resolve itself. It's going to take some action, and it takes organization. I'll just say it. We hear about all the things that are going on at the Social Security Administration, Can be a complex process before this, but as we close Social Security offices, as they lay off Social Security employees, this process is going to become even more difficult to complete. So it's really important that you not wait and ignore notices, and that you take those steps, because with less people to pay attention to your issue, the more likely it is to become harder for you. So those are the things that are just practical. Unfortunately, that's the circumstances that we're in. So it's really important for you to not ignore anything that comes from Social Security in this environment.
So one last question about the notice. If I have a payee, does the payee also receive a copy of the notice, or does the notice just go to the recipient?
It should absolutely go to the representative payee. So if you have a payee on file, the payee's address is actually where notices must be sent. And in fact, if your payee didn't get copied on an overpayment, that may be an argument for relief for you to not have to repay this overpayment.
I want to quickly transition to the effects of an overpayment if I missed the deadline, if I did get terminated off of my benefits. There's a lot of things that are attached to my Social Security, such as Medicare, and some recipients get extra help. That's all attached. And so I'm no longer receiving my benefits because I did not catch this overpayment. I'm unable. They say I'm reliable for it. I've done everything. Dr. Shear, I really would love to hear your input on how can this affect me getting the care that I need to also maintain one of the reasons why I was eligible for Social Security in the first place.
Fortunately, this is one of the easier things with this change. I think I'm pretty safe in saying that I'm the only person on the panel who both gets Social Security and Medicare, so I know what a trial it is to deal with them. But you will not lose any benefits as far as you're no longer not covered for Medicare, you're no longer ineligible, any of those things will happen. You are still covered. It is, at least in the past, they have not taken away Social Security paying for your Medicare Part B. So if Social Security was paying your Part B, if it was coming out of your check, that will continue to happen. It's not quite as clear what will happen if you have a Part D, which is your prescription drug benefit, or if you're a part of a Medicare Advantage plan that has a premium. Many of them don't, and obviously that won't be affected. But if it does, it's not clear whether or not they will continue to take those out of your Social Security check before they hold back all the rest of it. So you will still have your Part B paid for. If you are getting extra help from Medicare, or you have Medicaid, which has been paying your prescription medications, that will still all be intact, and you really don't have to worry about any of that. But I'll state what everybody else has said. If you get a notice from Medicare, and you need to be careful because we get so much mail from people who make it look like they're Medicare, and you have to be really careful with that. But if you get one, don't ignore it. Read it. If you don't understand it, get help from somebody who does. Medicare will not text you, and they will not call you about anything. So if you get a call or a text from somebody that says they're Medicare, they're not. Ignore them and block them. But as far as your continued coverage, you should be, perfectly safe. If for some reason there's a mistake and they withhold all of your money and don't pay your Medicare premium, you're going to get a notice from Medicare saying you didn't pay your premium, and if you don't pay your premium, you're going to get your Medicare terminated. And that is a big deal, which you do not want to happen. You'll get several notices, but basically within 3 months of that first notice, you're not gonna have Medicare anymore. You're still eligible for it, but you won't be able to sign up until open enrollment, which is from January 1st through the end of March, so don't let that happen. Bottom line, you should be just fine. Don't ignore any notices that you get from Medicare.
If for whatever reason someone's Medicare is terminated, so they have an overpayment, it's 100% overpayment. From what I understand, the Medicare Part B premium, Social Security is still supposed to pay that 175, whatever the amount is. If somehow, some way, the Medicare Part B premiums are no longer being paid by Social Security, and I'm getting letters threatening that I may lose my Medicare benefits, who do I contact? Social Security or Medicare? Because I remember my mother, her Medicare Part B premiums were stopped, and we're going back and forth. If Medicare would tell us to call Social Security would tell us to contact Medicare, and it was like a volleyball.
It is incredibly confusing, and different people are handled differently. I have no idea how that happens. And I went to figure out if I got one of those letters, could I say, don't take it from my Social Security check anymore, I'm just gonna pay it directly. And I went on the Social Security website, there's no way to do that. I went on the Medicare website, there's no way to do that. You will get instructions in that letter of a phone number to call or or a website where you can pay online. Not everybody can pay online, some people can, some people can't. And they will give you instructions in that letter. But if you don't have that letter, I would look on your mymedicare.gov website and your Social Security .gov website to see that letter, because if you don't have it, it's going to be incredibly confusing to find out where you're supposed to pay. I mean, it's going to be really hard.
Yeah, Miguel, we've been talking today about overpayments and about the changing policy that's going to go in place tomorrow. I do want to remind folks too that a lot of times when you get a notice of overpayment from Social Security, you'll also get at the same time something called a notice of planned action, and these are distinct issues. So an overpayment, again, is the government is saying that we paid you too much for benefits in the past. So the overpayment notice is a backward-looking notice, saying we paid you too much and you owe us back this money. And so the steps that we've addressed today about filing reconsideration and a waiver and a repayment agreement or adjustment of recovery of repayment are really important. But you also may be getting this notice of planned action in the mail for separate reasons, saying, in addition, you're not going to be eligible for benefits going forward. And it's really important for you to know that you need to respond to that letter as well. If you disagree with that determination that you should not get benefits going forward for some reason. So Nick talked before about one of the most common reasons for getting a Social Security overpayment for a Social Security disability insurance beneficiary is because you've engaged in work activities and you got caught up in the complex rules about work incentives. A lot of times that work activity is also going to cause you to be terminated going forward. So again, the focus of today is overpayments and overpayment recovery and the 100% withholding policy, but also always make sure that you file appeals on the plan action going forward if they're going to terminate you from benefits. Do you have appeal rights for that as well? So just an important distinction. We don't want you to not follow through on other notices you may get about future actions as well.
So, okay, the overpayments, the back to work rules are complicated. How does someone who's on Social Security retirement or widow survivor benefits have an overpayment?
This is a good question. So, so we talked about other types of Title II beneficiaries. It could be children that were receiving Title II benefits because of a deceased or disabled parent, or a widower or widow who was getting benefits because of a deceased spouse. Any overpayment that the deceased or disabled or retired wage earner was liable for, other people that are getting benefits on that wage earner's record are also liable for the overpayment. So that's one area where we see a child, a 15-year-old who's getting child benefits because their father was insured and is now deceased. If the father had an overpayment for some reason, the child also essentially inherits that overpayment. Now that child, though, can request a waiver as well and request adjustments of the repayment rate. But coming back to another part of your question, though, was about, well, how can a retiree, a retirement insurance beneficiary get an overpayment as well? There are various ways. So individuals that take early retirement at the age of 62 and do decide to do some limited work. There are certain caps that if you work under, then they can reduce your early retirement benefits, and so if they don't catch that in time, then that can cause an overpayment. So there are various ways that people getting retirement insurance benefits can get overpayments as well. But the vast majority of Title II overpayments that we see are going to be folks that are getting disability insurance benefits and have been caught up in the complex work activity rules. But again, there are other reasons too.
I would just add one, I'm not gonna say it happens a lot, but it seems maybe the most unfair oftentimes is on a retired worker's record or a deceased worker's record, when you have family members who can become eligible to get off that record, and then there's only one pot of money that the whole family shares, right? So you might have children on there, but now let's say the spouse has reached the age of retirement and can pull down. Well, when they become eligible to pull off that record, they now have to split that record up, and that can create overpayments for the people who are already receiving on the record, and that could seem very unfair because you're in the same family, you're sharing the same pot of money, and now you're owing money. It doesn't happen all the time, and it's a very specific scenario, but it is often a time where you can seek some of these equitable relief in that situation, because it's something that you cannot control, right? It's just one of those things that happens based on the rules, and we actually do see it somewhat often, unfortunately. So I would just say, if you're in one of those scenarios where you have special needs children and they've been pulling off the record and you're going to become retirement age, it can be something that you want to prepare for. I think that's the most common family scenario that we see that.
And thank you. That was some good overview on some topics that you don't really hear of but can occur. One thing I was thinking was, if I received the overpayment, and I'm looking at all the forms, and our community here, guys get to take those forms home today. They can get a little bit complex, right? So what can I send? Because in all of our roles, we advocate, we teach. What can the community do when they're looking at these forms? What should they send back? And is there any other documents that are relevant that they might not think of, because, this is really crucial. We're talking about thousands of dollars in front of them at that time. And if y'all wanna follow along, the forms are in your packets.
I'm gonna pass it along to everybody, but I wanna make sure, that they have made improvements to the form, but the waiver is still 10 pages long. And it's easy enough to say, just read the form, right? It also has a lot of charts for numbers. I think that it can just be overwhelming, so getting help, when you need help to understand it is really important. And to also not panic, because not everything on the form applies to you. So I think just taking it slice by slice, question by question, is the best advice, because not everything is gonna be applicable, and those things you can skip. And more importantly, we mentioned the differentiation between Title 16 and Title 2 and the SSI and SSDI. If you're an SSI recipient, there's a box on that form that says, if you check it, you don't have to go any farther. So if you keep going, you've wasted your time and provided information that you do not have to provide to Social Security. So just make sure you're not doing more than you need to, and I would just, my practical advice would be like, take it question by question.
Yeah, that's great advice, and the other thing to remember is that, you're not limited to what you put on these forms. You can always go back to the agency, you can always send in more information. What you need to fill out is gonna vary, just depending on what you're doing. Obviously, if you're filing a request for reconsideration, the most important thing is just to say why you think that the overpayment was wrong, and, provide any documentation of that, and that's just gonna depend on the specific case that you have. If you're filling out a waiver of overpayment, recovery form, the most important thing is to, so I think Brian mentioned the criteria that you have to meet, so it's, you have to tick a box that says you were not at fault in creating the overpayment, and that you can't afford to pay the money back. And then after that, the most important thing is, the most important thing is going to be to provide any proof that you have that you were not at fault. And any proof that you have that you can't afford to pay the money back. So for, not being at fault, it might be trying to find any proof that you told, and I'll just say with a waiver, fault usually boils down to like showing that that you told Social Security everything that they want to know. So any proof that you called them and told them that you were working, any, like if you sent them, copies of your pay stubs, like making sure that you got proof that you did that. I realize that for a lot of people, that's a tough thing to do, because, if you gave them a phone call and they don't say, oh, this our overpaid person called us, and I mean, if they don't have that in their records, then any proof that you can pull together is incredibly important. And then for being able to show that it will be a hardship to pay back, if you're not on SSI, then it's going to be, showing your monthly, what you're paying in rent, so your lease, or anything that shows what you pay in rent, in utilities, in anything that shows what you're paying, on a monthly basis for food, is what you would do to show that. And if you're negotiating a change in the overpayment recovery rate, it's actually going to be very similar. That's really going to boil down to you being able to show, what a hardship it would be to have your check taken. So that is showing, what your expenses are, what you're paying in rent, what you're paying for food, what you're paying in bills. And, just that's what they use to sort of establish what you could actually afford to pay back.
So I just have a comment, if that's okay, because we're about to wrap up. So, in tax, and I'm asking you all, since as Social Security professionals, if I'm returning to work, would it safe to assume, so I have more than one, I should keep my pay stubs during that time period that I return to work?
Well, technically, what you should do is you should mail your pay stubs or a copy of your pay stubs
Okay.
to Social Security.
That was my next part.
Yeah.
Question. So,
Every month, but.
okay, so I should send my pay stubs to Social Security every month. And the tax clinic, when I'm sending tax returns or sending documents on behalf of a taxpayer, I send it certified mail return receipt. Not only do I send it certified mail return receipt, I write the certified mail number tracking on the actual cover letter on it, because the IRS sometimes sometimes says, well, how do we know that this is what I requested, that you sent certified mail, and I make a copy of the envelope?
That is a good practice. So there's a customer service crisis right now at Social Security, especially at the field offices. And it's a good practice to always document anything that you send them. So certified mail return receipt is a great way of doing this. If you do go in person to Social Security to a field office, which unfortunately you can't do unless you have an appointment right now. If you submit anything in person at a field office, make sure you ask for a stamped copy of what you submitted, so you have proof that you actually submitted it. It's really important to do. It's a very, very large agency, things get lost all the time. You may have been doing your due diligence and going down monthly to report earnings, and handing them off, but you're not gonna be able to prove that you did that, though, at a later date, unless you received a date stamped copy of what you submitted. So, that would be a good practice. Faxing directly to your field office is a good practice. I know it sounds outdated, but if you fax something to the field office, then you have proof that you actually faxed it. That's a fax confirmation sheet. So always document when you're submitting documentation to the Social Security Administration for any agency. I think that's the case. Coming back to some practice pointers about filling out these forms. So when you are filing, if you're trying to contest the underlying overpayment and you're filing your request for reconsideration, you'll get an option on the form about whether or not you want to have an informal conference or a formal conference or no conference at all. I think it's a good advice to always request a formal conference. That way, they have to give you the opportunity to come in, review your file, and talk to you directly about the overpayment, and you can explain to the field office worker why you believe the overpayment's incorrect. So formal conferences are really important, and that will be an option on the request for reconsideration form, which is the SSA 561 form. Also, it will be discouraging when you get a denial of that reconsideration, but what I want you to know is that you have appeal rights further than that initial level of denial or reconsideration. Eventually, you would have the right to request a hearing to go before an administrative law judge. And a lot of times, you're going to have to do that for these overpayment matters. So you can actually sit down before an actual administrative law judge and discuss why you believe the overpayment should not have occurred based on the merits. The same procedures, appeal procedures apply to waivers. So say you file a request for a waiver and it's denied, you have appeal rights for the waiver denial as well, where eventually you can request reconsideration and then request a hearing to go before an administrative law judge. Something else, another practice tip about waivers, when you file a request for waiver of overpayment, you're entitled to a personal conference at the field office before they deny your waiver. So for a waiver, you're absolutely entitled to have the opportunity to go in and review your file and to talk to a field office worker and explain to them why they should grant the waiver as well. If you get a denial of the waiver without the personal conference happening, that's a big issue. You know, that's something that you contact Legal Aid of North Carolina or the Charlotte Center for Legal Advocacy about. These forms are really complicated. Unfortunately, despite asking for assistance from the field office, you may not get the assistance that you need to fill out these forms. Do your best to get help from family members or advocates in the community or attorneys that do this work if you need help filling out these forms. Also, these forms, especially the waiver form that Cassidy and Nick mentioned, that's 10 pages, hasn't been updated since significant changes in Social Security's rules about waivers. And it's unfortunate, but there are some additional exceptions when you don't have to submit documentation about your income and expenses. So for instance, if you have an overpayment from Social Security, but you also receive food stamps or SNAP benefits, then Social Security is not supposed to require you to submit all income and expenses anymore. The fact that you receive SNAP in your household should be sufficient to show that you can't afford to pay back the overpayment. You still have to show that you're not at fault, but it's assumed that you don't have the ability to repay because your household is getting SNAP benefits. Or if your household income is below 150% of the federal poverty line, it's assumed that you can't pay it back. If somebody in your household is getting Medicare Part D subsidies, it's assumed that you can't pay back the overpayment as well. Again, this waiver form, it's the SSA 632 form, has not been updated to Social Security's own policies. That's a significant issue because the form is really helpful for guiding the practice, and here's a situation where the form doesn't do that. So seeking out advice or help is really important for these cases, and I encourage everyone to do so.
And just to back up a little bit, since we were talking about best practices when we're submitting our pay stubs, there is also an online option. That's a website called mysocialsecurity.gov. And for some people who receive Social Security who do work, that might be a better option. It may be easier to scan a pay stub than to send it certified or fax it.
So I always tell people all the time, if I do stuff, start taking pictures of it and email it to yourself. So that way, I know Brian said, sending the pay stub you all, because I didn't think you were gonna say monthly, sending them monthly, and it comes down to not having proof, take a picture of it, email it to you, email it to yourself, so that way you'll have the documentation and there's no issues of losing it and trying to contact your former employer to get copies. Because I know a lot of this, now everything's electronic. All the pay stubs are electronic, and so you can at least download it and save it, and then email it to yourself, because I know people change phones, if you're anything like my mom. Yes.
So we are going to turn it over to maybe a possible one or two from our community members. So there's a lot of changes that's happening. Our recoupment is now turning into 100%, but please, this panel was put together to inform you guys that there's still solutions. Do not get terrified by the changes. This is just something that is going back to how it was over a year ago. So these solutions are still now prominent. Anybody have a question for our lovely panel?
My question is mainly on the dates. When you say you have 30 days to respond, when does the first day start?
Right, so basically it's 30 days from when they say you received the notice. So basically, the date of the notice plus 5 days, because that's what how long they think it takes to get to you.
Okay, a real scenario. If I tell you that my mail has been going somewhere else, and I've been getting it like a month later, and I've talked to the post office and they're aware of it, can the documentation of my going to the post office be my backup for my that 30-day window that I can say, well, I didn't get it till 40 days later?
Absolutely, and the other thing I want to stress is that regardless of whether you hit that 30-day deadline, Social Security has an obligation to suspend your recoupment when they receive a waiver or when they receive that appeal. So, it's not that, if you miss that 30-day deadline, they'll just take 100% from you. They will shut off the recoupment once they get it, and once they process it.
Yeah.
So if I don't respond within 30 days, the next month, I more than likely my benefits have.
You won't need a notice because your check won't be there and you'll know that something's wrong. Yeah, absolutely. And I want to say that 5 days is sort of a presumption, but you can it's a presumption. It's something you can prove.
Yeah.
And we do a lot of that, right? Like,
Right.
when I say keep your documents, I mean keep your envelopes too, because we might be able to show that they didn't mail it out. Their notice might say January 1st, but they didn't mail it till January 31st. It's gonna be hard for you to get it in 30 days if they took 30 days to get it out the door. So there's a lot of ways you can rebut the presumption. The 5 days is just sort of like a grace period that they go ahead and build in just you can absolutely challenge that, and we do. We often have to, investigate those type of things and challenge them, because a lot of times people find out for the first time that they have an overpayment when they don't get their check. Same, I mean, we see that with like Medicare and Medicaid too. You don't know until you go to the pharmacy and they won't give you your medication, right? These notices get delayed, they get lost, they don't get sent all the time.
So a question online, is that 30 calendar days or 30 business days?
Calendar.
And someone had mentioned about in the SSA letters, if, something about they put letters in the file. Can I go and look at my file on my socialsecurity.com on any letters they may have sent to me?
I believe so, yeah.
Okay.
He has one, so he might be.
Yeah. I think all of the letters, both from Medicare and also from Social Security are online.
Okay.
Yep.
So, because I know I do get some of those scam type letters, and I look at, you know, which one of them, I just don't look right, you know, type of thing. But follow up my prior question, what I have started doing, because in October, I didn't get no mail. So what I started doing was, I write on all my mail, the date I received it. And if it's more than 5 days, and generally is 10 days from the date that I received it to, if there's a postmark, most of the time it's a barcode, so you don't know what the heck it means. But I do keep the envelope, because I do get letters from the same person from last month, and it'll go, have a little yellow sticker on it. It says unable to forward, da, 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 da. I'm like, how's that? But I do keep it, so that's a good thing.
But if you do have an account, you can usually put in there a request for notification, and you'll get an email from them telling you you have a new document,
Yeah,
and you don't have to worry about your mail.
yeah, okay.
It is ssa.gov.
SSA.gov.
Yeah, okay. Thank you.
Yeah, you said something that piqued my interest. I'm a rep payee for one of my relatives, and it goes directly to the bank account. And I really don't pay too much attention to it until I just happened to look on it one day and I noticed there was a decrease. And I go, well, what's going on, you know? So I did, I think I called the Wake County, this was in Wake County, whoever I called, and they said, oh, there's they paid you her too much. But if I'm her rep payee, did I hear you all say that I should have gotten notification of that? And that it may be grounds for a waiver or something like that? Could you expound on that a little bit?
That's right, and I just want to, as a rep payee, you can be financially responsible for that overpayment. Have assumed financial liability for that person, so they can come after you for the overpayment. So that can be a really tricky thing, but I'll pass it to my colleagues to kind of talk about, you should get notice, but there are lots of reasons.
Yeah, and that's a good reason to say that you might have missed, say, a 60-day deadline, for example.
Okay, thank you.
I guess my question in that situation too is, that's really important. If you're a representative payee, I know a lot of people do this because they want to be, they're trying to help their family members out, but it can be a really messy situation with Social Security. So make sure we have, I think I still have some upstairs, but you can request a guide that tells you about all your obligations and responsibilities and rights as a representative payee. And, we see so many issues, and I know some of there are what we call the fee-for-service representative payees that do this, and that might take advantage of people. It's really important to know your rights and responsibilities as a representative payee, because you don't want to get yourself in a situation, but most importantly, you don't want to get that beneficiary in a situation that affects, can take their benefit away. So I think that's, it becomes, Brian mentioned the customer service crisis that we're facing. I can see that being an even bigger problem for.
Do you anticipate any changes to Title 16 as far as like he said, tomorrow they're gonna do 100% as opposed to 10? Are they doing the same thing with Title 16 and SSI?
Yeah, that's a good question. So the change in the recoupment policy of full withholding that will start tomorrow, first of all, only should apply to new SSDI or retirement insurance benefits overpayments that are found tomorrow, that are incurred tomorrow. SSI though is always going to be 10%. And the reason why is that 10% cap for SSI recoupment is in the Social Security Act itself, whereas there's not an equivalent cap in the Social Security Act for SSDI or retirement insurance benefits, what we're calling Title II benefits. So SSI beneficiaries, the most that you can ever see taken out of your check for an overpayment is 10%. That's the same. That's in place right now. It's going to be the same tomorrow. It's going to be the same a week from now, unless Congress decides to change that. That's correct. So even SSI beneficiaries that are getting a 10% recoupment, they can, first of all, appeal the overpayment like we talked about. They request waiver of the overpayment, but they can also request a lower recoupment amount as well. Social Security can go down as low as $10 a month for recoupment, even for SSI beneficiaries. So you do that by filing that request for change in repayment rate. And certain SSI beneficiaries are entitled to the $10 minimum as a matter of right. We're not going to go into detail about that, but something you should know.
We actually have a question online, if that's okay. Someone asked, does lottery, I'm just gonna say, he said gaming, not he, I don't know, but gambling winnings, can that create an overpayment?
It can if you're getting SSI, because basically SSI, Social Security reduces SSI by any other income that you have, and that does include gambling winnings or lottery winnings. For Title II, for SSDI retirement, for disability basically, the only thing that they really look at is earned income. So that's income that you got for doing a job.
And just the practical explanation there is, you paid for that Title II benefit, right? Like, if you win something, they can't take it away from you because you paid for it. Whereas SSI is something that is more of a needs-based benefit. You didn't pay into the taxes into the system to become insured. So they can't just take your Title II benefit away from you unless you're doing all these different activities that sort of go against the definition of disability. So there's a really basic reason for that. And I would also add that for SSI recipients, if they have a big win, right, and this can go beyond your SSI, which can also be a big thing, if you hold on to that money, it's now what we call a resource or an asset. And you're only allowed to keep $2,000 in the bank if you're an SSI recipient individual, $3,000 for a couple. And that's, if you had a good day at the races, that can be, and you hold on to it, that can be a big problem, because that doesn't just reduce your benefit, you're not eligible for the benefit if you're over the resource limit. And that can affect your Medicaid, which SSI recipients automatically get in North Carolina. So just keep that in mind when we're getting into Title 16 world SSI. There's a lot more rules about financial eligibility. While there are more favorable recoupment rates, you can lose that money really quickly because there's a lot of rules about it.
I had just a couple of questions. You talked about the family unit earlier, and so a lot of people don't think about divorced spouses. And so that could affect the divorced spouses so they would be potentially eligible for the overpayments.
In fact, I've had that case where I had a divorced spouse who was my client, and luckily we were able to get her the divorced spouse benefits, but what that in turn caused was an overpayment to the current spouse, right? So that can absolutely happen in those situations. Yeah, divorced spouses are entitled to benefits under certain circumstances. So And that can affect the family unit and the family max benefit.
And then my second question was, if they don't do the 100%, or even if they do the 100%, or I get a waiver and I reduce it to whatever, does that now affect any other public benefits? Would I be eligible for anything further in the public realm of benefits? FNS, Medicaid, if I weren't currently, or if I am currently, does that affect any of those benefits? Do you know?
Generally, for other means tested benefits like food stamps, they're gonna count your income as the income that you would have received before the overpayment reduction, or the recoupment. So say you were getting Social Security disability insurance at $1,000 a month, Social Security is taking your full check, so you have zero money coming in. Food stamps or SNAP or FNS in North Carolina is still gonna count the $1,000 check that you would have received if it wasn't being recouped as your income. I'm pretty sure it's the same for Medicaid as well. Does that answer your question?
And I think, and as Dr. Shear said, I mean, if you just want to reiterate, but it does, it will affect all those QMD or MQD, but if you get Medicare, same thing. It won't like make you eligible to get Medicaid to pay your Medicare premiums. Sorry, passed it on. But was there any effect on that?
No, it counts as income.
All right, so I do want to be very, courteous of you guys' time. So this is the conclusion of this event. We have captured a lot. Thank you for joining online. Thank you for coming in person and joining us during this overpayment panel. There's a lot of takeaways, but one, most importantly, is that the solutions still stand. And there were a lot of solutions today on this panel. Thank you for your time today. And please continue to follow us online at Charlotte Center for Legal Advocacy and Legal Aid of North Carolina. Thank you.
Woo!